arise, we would waive that.
And Your Honor, we, from the Assistant Public Defender, Chinazi Kiriaki, representing Mr. Jerome Burns in this matter, we also do not believe that there is a conflict in this matter, and if such conflict should arise, we waive that as well.
All right, very good. Can we get him out? Court does call the case of People State of versus Jerome Burns.
Good morning, Your Honor. Marie House, Assistant Prosecuting Attorney, back to people.
And good morning again, Your Honor. Assistant Public Defender, Chinazi Kiriaki, on behalf of Mr. Jerome Burns. Mr. Burns, state your name for the record, please.
Jerome Burns. All right, are we ready to?
Your Honor, a few things. I've been communicating with defense counsel. We have witnesses here. Victim is on her way. Sergeant Matthews is driving her. I believe they hit some traffic, but we have our other witnesses present and ready. I did want to make a record. We received a great deal of evidence from defendant's phone. As the board likely remembers, we had a preliminary, an extraction. I shared that with defense counsel because it was of potentially exculpatory nature. I was also though very clear that's a preliminary finding. There was ongoing extractions from the phone and analysis that needed to be done. I was initially sent 2 zip files of what was extracted from the phone. Background to this is that there was at least one hidden folder in the defendant's iPhone that had biometrics associated with it. So essentially they could get into the phone, but they weren't able to get into the hidden folder. So we were looking at options for that. The extraction we received didn't work on any of the county computers, so I was unable to, yes. Ironically, I was unable to pull that up. I had informed defense counsel of having that, but also that I wasn't able to open it. So the next step was asking them, hey, is there another way we could do this where I could actually view this evidence and share it with counsel? I believe it was yesterday. And I will say Sergeant Matthews went above and beyond in trying to do things quickly. He was able to get 2 thumb drives, one for prosecution, one for defense, copied over to our office. I notified defense counsel. I believe they have picked it up since and are in possession of their copy. But it's a lot of information, Your Honor. And a lot of the information relates not only to the preliminary report that I shared with counsel, in essence, it gives a lot more context than what I have been able to view, give context to that first piece of evidence. It's also evidence that we would want to ask the victim about. So the potentially exculpatory information, I believe, would necessitate the victim testifying again, unfortunately, given that evidence, but also the evidence that we are just recently in possession of would speak to that very closely. And I can go into further details at court.
I just want to make sure I'm understanding. So there's evidence that may be exculpatory, which would require the victim to reappear and testify.
Correct, Your Honor, to give context to that piece of evidence, but we also now the evidence that we have received as of yesterday, it gives a greater context to that preliminary piece that we shared with defense.
Got it.
The reason for sharing that first is because of the potentially exculpatory nature. I wanted to make sure they had it and they were ready. But of course, there's a lot more to it. And what we have other witnesses, I'm ready to continue with those witnesses so that they don't have to keep reappearing. But I'm not sure I'm comfortable proceeding with the victim's testimony until both sides have had a chance to review this additional evidence off defendant's phone.
Okay.
As I stated, victim is on her way here. She does have a son. I don't know if she was able to get childcare for him or he'll be with her. So I don't believe we reached a consensus this morning, but I did speak to counsel about, for her testimony, do we need to keep her here and take that testimony today? As I stated, and I'll state again for the record, I'm not comfortable until both sides have looked at the evidence. I'm not comfortable directing her on it, and I'll leave up to counsel how she feels about cross-examining without those pieces. But as for the other witnesses, Your Honor, we would be ready.
Your Honor, we find ourselves in a pretty difficult situation because we have not been able to review all of the information from the thumb drive. I asked Sister Counsel, she's unaware because she hasn't gone through it either, if any of the information in the thumb drive may pertain to the witnesses that are present now and ready to have testimony taken from them. I don't see why there would be. However, there was some information just in the preliminary pieces that were sent over last week or a few weeks back that may have occurred around the time of the interaction with one or maybe all three of the witnesses present today, specifically some communication between my client and the complaining witness. We're not sure who was around at that time, but I just don't know what else is in the phone. There's a great deal. I am not experienced in sieving through this type of data. I'm literally just clicking on every folder or file and
I thought you worked for the NSA. No, I'm sorry, go ahead.
Not on the right.
In my prior life.
Yeah, okay.
So, and that's why I find it difficult to say, yes, I'm ready to proceed on the three witnesses that we have. Yes, I'm okay with an adjournment of, the information from the complaining witness. And I know my client's position 100%. He has been in custody throughout this entire period. He is very eager to resolve this matter. We received some very disturbing news from his family yesterday. His father's currently in the hospital and he's been really struggling to assist with his mom. But I know that my conversations with him have always pulled out his desire to move forward and continue this case along. So we're really at a crossroads right now, Judge.
Right, and just so that we're clear, part of the reason the court agreed to adjourn the matter was because my understanding was the defendant believed that there was something that was exculpatory on the phone. And so that's why we even started down this path. Just that there, I'm not blaming anybody, it's just what it is. With reference to, I'm sorry, Ms. Eckenroley, were you done?
Sorry.
Okay, no, I just wanted to make sure. With reference, you said you had three witnesses today.
We have two witnesses, Your Honor. Two of them are in the gallery. One is the officer who responded. The other one is a social worker who spoke to the victim at the time at the hospital after the assault.
So
they would be ready. We also do have Sergeant Matthews. Sergeant Matthews would be able to start today. We may want to recall him after the victim's testimony, depending, but he'd be the third witness that could start testifying today.
got it.
And I share defense counsel's lack of knowledge of technical things. So when she asked me about the messages, I was able to get through some of them. Of course, not all of it. It is a great deal of evidence. And I would agree that there are text messages, and those we do have timestamps, and Sergeant Matthews could speak to from defendant's phone, defendant messaging victim around the time that it seemed it was becoming clear to him that there might be some police involvement and things like that. I am not sure if that affects Officer Morton's testimony. I mean, he responded, he did what he did, but I'll leave that.
Well, I guess I initially, let's take out, there's a social worker to testify who, and this may be the more difficult one for the court to try to analyze, and maybe part of the defendant's point, that
It wasn't me.
oh, you don't care? You don't care? No, man, I feel, that thing goes off, nothing. Then that goes off, nothing. No. You got me? Okay, thank you. No, don't worry about it. I feel safe. So with reference to the social worker who spoke to the victim afterwards. I would have to say I might be a little bit concerned if there are concerns with what the victim has testified to, and the victim is relaying certain information to the social worker. I'm not sure, maybe the parties can clarify it if they can, or I don't know. It would seem to me that getting through or understanding what's on the phone is also going to be cloaked in that same context as the victim. If that made any sense.
It did make sense, Your Honor, and I'm racking my brain as to with the preliminary information we have. My concern, defense counsel might disagree. My concern isn't necessarily what the victim said. Our understanding of the evidence, especially with the little of the new evidence I've reviewed, is that the potentially exculpatory evidence, our perspective is that it's not exculpatory because there's a greater context and we have theories and so on. And I think the evidence will highlight that. However, again, like I said, defense counsel might disagree.
Well, and I guess my point to that might be, she might disagree or may not know.
Correct.
Which may be worse.
Yes, Your Honor.
Because it's that greater context, I guess, piece of of that evidence that might not only have some greater context to what the victim says, but might also have greater context to what the victim said to the social worker and what the social worker said.
I understand.
Is that sort of what you're referring to, Ms. Ackenberg?
That's correct, Your Honor. But yes, not knowing what's on the phone, I don't know how it pertains to our social worker or even the officers, because again, from the preliminary information, there were some communications that fell within that timestamp of after the event, during the time that other parties began to get involved. I don't know. And we just know that from the preliminary.
And you know, the difference between the preliminary, other than the obvious difference, the preliminary information we're able to get evidence about the time stamps, because in part of that report, in part of the supplement, I believe, Sergeant Matthews outlines this time, this day, this text was sent, and so on. With the new evidence, I don't have a way of knowing the timestamps on it, and the defense does either. So we would need someone to testify to all of that. And I don't know if Sergeant Matthews has had a chance to review all of it, because he similarly had a problem opening the initial files and has only since yesterday had access to all the information off the phone.
And Judge, I just want to, I guess I need to just put this on the record. I know that I think it's important that the court notes that my client never requested for the people to get his phone. My client never requested.
Right. I mean, I agree with that piece, but and I'll certainly let you finish. What my point was, the defendant, at least as I was informed, the defendant wanted his phone, which he believed to be in his property.
Correct.
That his reason for that is because there was a belief that there may be something that might be exculpatory on the phone.
Correct.
Okay. When the defendant was, or at least the court was aware that he wanted the phone, I was then informed that the police agency had picked up his phone and had his phone. So if anything, I'm saying in terms of the request that it was the defendant who was requesting the police go through his phone, I don't think that's not what I meant to say. What I meant to say is it transpired that way because there was something there. The people, to their credit, then said, if there is something that is exculpatory, then we want to make sure that the defendant has that. So that might be a clear picture, but I'll let you go ahead.
Sure. Yeah, so that is correct, Your Honor, but I think the piece that the court should probably also know is that the only reason that they picked up the phone was because my client was asking a family member to come and get his phone for him so that he could instruct us on how to get that evidence out of his phone. And the police department overheard that call and then took it upon themselves to come and pick the phone up. And then that's where we got into this entire delay, because there was negotiations as to how we were going to get it to the phone, and things of that nature. So it does not change where we are. I just felt that it was important to clarify the record to that point.
And please understand that I wasn't trying to, and I think I may have said it at the end of my first statement, I'm not trying to blame anybody for the delay. I'm not trying to say the defendant is trying to delay this out or the people. It is what it is. I just wanted it that we, and I'll take you at your word for how or why they picked up the phone. But suffice it to say that somehow or another, that train started rolling down the tracks.
Correct.
And so
Absolutely.
we all had to deal with it. So.
If I could just add one thing, and it's simple for the record, because I know everybody here is aware of this. When we were here and there was information from the defendant that he wanted potential exculpatory things off his phone, I want to be clear, it wasn't a PCC. We were here for exam. The victim was here. People were ready to go. What I want to add to that is that the defendant also has a bond violation, and I know he hasn't been sentenced on that bond violation, and I'm not sure what the sentence would be. But there are many factors that go into this, and that is one of them. And the violation is such that it's not just a minor technical violation, it's quite a serious one.
So I guess the defendant wants to proceed right away, and I get everything that counsel has stated, but I'm worried, Ms. Eckenroley, that you'd be placed in the position of attempting to try to cross-examine a witness for your client's benefit, where you don't have benefit of everything. And that really is fundamentally my big concern.
Your Honor, I'd say the people share that concern, and in communications with counsel, I also want to be clear that if we don't continue today, that is not from the people not being ready. That is not from the people saying we don't want to continue. In fact, as I stated, the victim is on her way despite many difficulties to try to make it here, and our witnesses are present. So for as much as it helps to the defendant's benefit, this is us also trying to be very careful in how we go about things. None of us want there to be issues on appeal. We all want to make sure that we're very careful in respecting not only the rights of the victim and the people, but really the rights of the defendant.
Right. Ms. Eckenroley, have you had a detailed conversation with your client about going forward today? I mean, I realize that some of the issues that the court is raising, you may not have because I've raised those, but you're smarter than I am, so you may already thought about that.
And Judge, I mean, if the court is okay with giving me a moment to, now that he's been able to sit here and listen to all sides of it, yeah.
I'm not going to have a problem with that. Let me, what I've said about the social worker, does either party see with reference to the two officers that same potential issue arising?
Your Honor, it comes out to what Your Honor very eloquently put. We don't necessarily know. I don't have reason to believe. There's nothing I've seen up until now that would suggest that there's, of the things I've seen, there's nothing that would make me think that we couldn't proceed with the officer's testimony. But
I'm sorry, I don't mean to interrupt, but the officer spoke with the victim,
correct, yes.
correct?
Yes.
And from speaking with the victim, a report, that's part of the report, right?
Yes, Your Honor. So there was an interview with the victim. There was an interview, of course, with the social worker who had spoken to the victim. And there was at least one interview with the defendant.
Okay. I mean, and I haven't had a chance to necessarily think that entirely through, but it would seem to me, oh my goodness.
Instant smile, Your Honor. Just making sure we're doing our
I can
jobs.
hang
just
out for
right.
a little while for the court's next recess.
Well, I'm out. No. All right. It is so good to see you.
Thank you. Good to be seen.
I'm happy now. Despite your,
Thank you.
despite your non-attention to my safety. I'm happy. Let me just put it in a nutshell. It would seem to me, and maybe this would be the conversation that needs to be had, that anyone who spoke with the victim is going to fall, in my mind, into that same potential concern regarding placing context around what her statements are. I think we're in the same boat. I picked the social worker initially because it was going to be difficult, but there was also going to be a closer conversation between the victim and the social worker. But I think if the officer interviewed the victim, that same thing is going to happen or potentially happen.
Your Honor, may we approach just briefly?
Well, no, this is where it starts. You know, I'm going to just tell you, I walked in here, two of my favorite attorneys, and I said, this is going to be a good day to come back from vacation. You have both ruined that.
Your Honor, thank you for the court's patience and allowing us to talk through a few things. As I indicated to Your Honor and defense counsel, I've looked through a great deal of the evidence. I was handed a essentially summarized report by the detective who did the extraction from the phone. I shared that for today's purposes with defense counsel. We both kind of skimmed through it. With what was in that report, I felt comfortable proceeding today with the responding officer, with the social worker witness, and starting with Sergeant Matthews. I was not necessarily comfortable proceeding with the testimony from the victim until I've looked at everything more at length. So I guess we wouldn't have a request to adjourn. However, we also understand defense counsel's side of things and want to be understanding of the concerns that she has at the time that she may need to look through everything. So we also wouldn't object to an adjournment at this stage.
And Your Honor, I think that she did state the fact that there was a new summary that was provided to us today by the officer who was able to do the extraction from the phone. I did have an opportunity just to glance at that summary. I spoke with my client. Previously, the court is always obviously aware that his position was for us to continue on with the exam today. In light of the new information, by way of summary that was submitted to us today, I need time to go over it with my client and see if there's any insight or context that he would be able to add to it for me. Most of this is communications with the complaining witness specifically. So there's just a lot of information that we have still yet to go over. So I guess that although my client, for the record, is not asking for the adjournment, we're just letting the court know what position we're in right now with the information that's been presented to us.
All right. Understood. And So from the court's perspective, and I'm going to adjourn the matter, finding good cause to do so. Counsel's been very good at explaining to me exactly where the parties are. I think it would certainly behoove the defendant to be able to have his attorney go through that information and then go through that with him in fairness. As I also expressed to counsel while we were in chambers, I strive to make sure that the decisions that I render in these cases, in every case, is the correct decision. And it would worry the court a bit that if there's information out there that is not being provided to the court that may give either some context or understanding as to the testimony that I'm hearing. So for those reasons, the court will adjourn the matter. I will be adjourning it, also part of the discussion in back, realizing the defendant is in custody, has been in custody. And that there are, without going into the details of it, vacations that are scheduled and other things, plans that people have made, and so that we can have consistency. We picked August 13th as a date to continue. Court's going to do, and that will do that August 13th at 9 a.m. The court, for its part, is flipping its docket to handle what would be in the morning, in the afternoon, to try to accommodate this and to make sure that we get this done in at least a reasonable period in time. Counsel has also let me know they think that will be enough time for them to be able to get through everything. So that there's a full understanding, and from the defense side, being able to also discuss that with the defendant. Right. So August 13th, 2025, 9 a.m. for me for the continuation.
And Judge, if I may address first? Your Honor, with obviously the court is very aware of the continuances that we've had in this matter. Mr. Burns has been in custody for 81 days to date from the date of the original arrest. I know that there is a current issue, or at least a bond violation that he has already entered a plea to, that the court has yet to sentence him for. I do not know what the court is going to do. I'm not sure if the court has been able to make a decision, especially based on the status of the case as is. I received information from my client's mother on yesterday that his father is currently in the hospital. He suffered a stroke on Friday, and he has been hospitalized since then because my client does not have telephone access or anything of that nature. He had been completely unaware of that until I had spoken with his mother, and then I was able to relay that information to him. She has been finding it very difficult to handle her husband's affairs and to assist with his medical upkeep, especially when he is going to be released by God's grace. He will be able to be released sometime soon, and he'll have a significant treatment regimen that he will have to undergo. I know the court is aware that my client lives with his parents and had been living with his parents prior to this situation. They're not considered as elderly, but they are older. And his mother will need some assistance. I know that the court has heard some testimony in this matter. We'd like to ask that the court consider giving him a bond that he would be able to post, ideally, preferably a personal recognizance bond. I know that there are things that the court can put in place to protect or address any concerns that they may have for the complaining witness. He is not a flight risk. The court knows that his parents have been at every one of his court hearings from the beginning. So we know that he himself will be at every one of the court hearings based on what he has assured us. The way that this case has gone in so many different directions, Mr. Burns 1000% understands that he is fully in control of what happens next. If the court is willing to give him a personal recognizance bond, I dare to say that he understands that any actions on his behalf would negatively impact his case, because they have. Everything that has happened thus far that has brought us to the number of continuances that we've had. I've spoken with them. Most of them, if not all of them, have to deal with some type of action that was taken by him. If that has not taught him that his actions directly impact the outcome of the case, or at least the ability for us to try this case in a fair manner, I don't know what else would help him do that. I believe that he is understanding the importance of maintaining his bond. I believe he understands the importance of no contact with the complaining witness in any shape or fashion, with the issues with his father, the assistance that's needed by his parents. We're asking that the court make a consideration of giving him a bond, and if in the alternative, judge, at least allowing him to be able to communicate with his parents so that he'd be able to keep up with what is happening with his dad. We prefer that he be given a PR bond. I mean, he has been trying his absolute best to aid in his defense from the jail. It has been quite difficult because he only has his parents to rely on to relay and give us whatever information they may have. So that is our request today. Primarily based on the number of continuances that we've had. I know we've talked about it on the record, and not that anyone is at fault for that, but he's been in jail for 81 days on this case, Judge, so we're asking for a personal recognizance bond.
Your Honor, we have a great deal of concern in this case. We had a concern initially when this case was charged. That concern has done nothing but grow as this case has progressed. We heard testimony from the victim, quite extensive testimony about the level of coercive control that this defendant had on her. That gives us no hope that that has changed. Part of the reason that we don't have that hope and don't believe that anything's changed in his mind for the better, at least if anything has changed for the worse, the actions he took while he was incarcerated after being given very specific conditions of bond. At that point, it should have been clear to him, if it weren't previously, that engaging in behavior that makes things more difficult for the victim, who is the mother of his child, is not going to be beneficial to him. What he then decided to do is make several calls, ensuring, first of all, he fought her having access to a vehicle to transport their sick child while we were in court. Even to the point where his father was willing to hand over keys, and we thought we had it resolved, and he refused. Then when the court ordered keys need to be turned over to the victim, she needs to have transportation. The court had a long conversation with him about the situation and what would be appropriate, what he needed to do. He then decided it'd be a good idea to have people, third parties, contact the bank, trying to get this car repossessed, going so far as to say the victim who was staying at the domestic violence shelter at the time, make sure that they come and repossess the vehicle as she's trying to unload her things. I mean, this is a woman who has had everything taken from her. She has no place to live. She had no transportation, and she's caring for a sick child, defendant's sick child. He also, during those calls, made statements about how he would have assaulted Your Honor, if he wasn't handcuffed. All of that is plenty concerning. In addition to that, he made statements on the jail calls, and we heard through the victim's testimony that he has made statements, and I believe the evidence we now have is going to corroborate that, of taking their son away, and that the victim would never see their son again. She also testified, of course, that that was part of the reason that she gave in this case to the sexual assault, and it was a big part of her concern in this case. So when we're talking about victim safety, we have concerns because of that coercive control, because of the hourly check-ins he required from the victim, knowing exactly where she is, who she's with, and so on. That doesn't just go away. We also do have concerns that he would take their son and disappear. So both for flight risk and for victim safety, we have a lot of concerns. We'd ask the court to deny the motion.
Yes, Your Honor. I just wanted to address a couple of the issues that were raised by the people. At this point, my client does not have a vehicle. The vehicle was turned over to the complaining witness, and obviously the court is aware that the vehicle is either not working or something to that effect, because the complaining witness has needed assistance from the people to get to court on each of these hearings. So he is going to completely have to start all over. We've already pled to the bond violation. I think that it should be noted that no contact with the complaining witness was actually made. There were attempts from my client. We do not deny that, Your Honor. Most of that was due to frustration and what he was dealing with at the time and just trying to understand how he found himself in this situation. He has taken responsibility for that. And I think that that should give him some type of a benefit of the doubt, Your Honor, because he has been able to take accountability and responsibility for the actions that he did commit. However, the complaining witness left the home that was shared by all of these parties well before this incident happened. He does not have any control over her. If he did, she would have still been in the house. The only reason that we're here right now is because their son was in the hospital and they were at the hospital together. Whatever control or coercion or dominance the people believe that he has over the complaining witness, there has been no showing that that is the case ever since she left the home. So I don't think that that is a concern that the court should have. My client has much more important things that he needs to worry about right now, rather than whatever it is that's going on with his relationship. He has not tried to contact her directly while he was here. The only contact that was alleged was the fact that he asked someone to go and have the car repossessed because it's up for repossession. And I mean, quite frankly, Your Honor, he is still financially responsible for a vehicle that he no longer had control over. And his position was, if I don't have control over the vehicle, then let the bank take the vehicle back and everybody will just deal with things the way that they were dealing with it prior to that. I do not think that the court should or would have any concerns with my client contacting her, having any issues. He wants to focus on his family, his father, and his mother. He has work that he needs to do, Your Honor. He needs to be able to help his parents financially. That is the position that we're in right now. He has to start all over. He has no leg to stand on right now other than a place to live, which would be at his parents' home. I think that a hot zone tether, a tether of some sort would be able to protect him. He doesn't even have a phone, Judge. The phone that he did have is in the possession of the police department. He would be using his parents' phones, if anything. So he doesn't even have much to work with. So I don't think that the concerns that the people have for the victim's safety or the complaining witness's safety in this matter are valid, because my client can barely take care of himself at this point.
The court, having looked at it and also having been familiar with the bond violation that I've yet to sentence the defendant on, certainly given, again, it's not anyone's fault necessarily, the continue time to make sure that all of the evidence is properly analyzed by each side. The court, in any sentence that it does impose, and I did represent this to counsel, will take into account the time that the defendant, I'm not making any guarantee as to what extent, but we'll take that into account in terms of any sentence that it would impose. I still do consider the defendant to be a risk to public safety and to the victim in particular in this case, and would deny the defendant's request for a bond reduction at this time. I will, however, given light of given notice of the circumstances involving his father. His father, I know, had been in these proceedings in the previous times, that I would permit, although I have revoked his phone privileges, to the extent it can be arranged with the Washington County Sheriff's Office and jail, I would permit the defendant to call his father while he is at the hospital one time per week, so that at least he can have communication with his dad. All right. And maybe then facilitate some of the issues that his mother might be running into in terms of the caring of the house. So, counsel, if you prepare an order to that effect. But once, so that I'm clear, once his dad leaves the hospital, his phone privileges will go back to the status of being absolutely revoked. All right.
May I just add one thing? I'd asked the court, because part of, and I was going to respond to counsel, but I felt it unnecessary at the time. part of the jail calls indicated that he was asking his parents to contact the victim to have her essentially get rid of this case. So maybe a warning so he's very clear that these conversations, once we cannot be about the case, about the victim or anything like that. Thank you.
Yes, and I think that ought to be clear, and you understand that, Mr. Burns. Yes. All right. So the case should not be discussed, certainly no directive should be given to your dad in terms of what to do or anything else along those lines. If I find that to be the case, that's just going to be another violation of my order, and I don't think we want to end up in that situation. All right. I'm doing it solely because having found out this information, your dad's in the hospital. I think that as an act of grace, the court is going to give you the opportunity to at least speak with your dad. All right. Okay. Thank you.
Thank you.
What makes this hearing fascinating is that nobody in the courtroom seems fully comfortable moving forward yet. The prosecution wants caution, the defense wants fairness, and the judge is trying to protect the integrity of the entire case before testimony continues. The hidden phone evidence became the center of everything, changing witness strategy, delaying testimony, and even influencing bond arguments. At the same time, the hearing shows how criminal court is never just about one issue. Evidence disputes, custody concerns, family emergencies, alleged bond violations, and victim safety all collided in a single proceeding. And through it all, the judge kept returning to one core principle: better to slow down now than risk an unfair outcome later.